meddling in our election. Will you be providing any updates to the American people?
Certainly not before the matter is concluded, and then depending upon how the matter is concluded, I mean, some matters are concluded with criminal charges, and then there's a public accounting and a charging document. Other matters, as was the case with the email investigation, end with no charges, but some statement of some sort. Others end with no statement. I don't know yet. And obviously, I'd want to do that in close coordination with the department.
Will you make recommendations to, presumably it would be the Deputy Attorney General or the Special Prosecutor, if one is appointed, as to whether criminal charges should be brought?
I don't know in this case in particular, but in general, we almost always do, especially the highest profile matters.
But you cannot yourself pursue criminal charges, correct?
Correct.
I think that's important for the American people to understand, because it bears on the question of whether a special prosecutor ought to be appointed. The FBI may inspire great credibility and trust, but the FBI cannot bring charges. Neither can the intelligence committees do so, nor can an independent commission. Only the Deputy Attorney General or a special prosecutor designated by him, correct?
Correct.
Let me close, because I am running out of time. Have you been questioned at all by the Inspector General in connection with the inquiry that I understand is ongoing into a number of the topics that we've been discussing here?
Yes, I've been interviewed. The Inspector General is inspecting me and looking at my conduct in the course of the email investigation, which I know this sounds like a crazy thing to say. I encourage, I want that inspection, because I want my story told, because some of it's classified, but also if I did something wrong, I want to hear that. I don't think I did, but yeah, I've been interviewed, and I'm sure I'll be interviewed again.
Do you have any regrets, or are there any things you would do differently in connection with either the comments you made at the time you closed the investigation, or when you then indicated to Congress that you were, in effect, reopening it?
Yeah. The honest answer is no. I've asked myself that a million times, because, Lordy, has this been painful? The only thing I regret is it maybe answering the phone when they called to recruit me to be FBI director when I was living happily in Connecticut.
And we would welcome you back to Connecticut.
Yeah, but I can't. And I've gotten all kinds of rocks thrown at me, and this has been really hard, but I think I've done the right thing at each turn. I'm not on anybody's side. It's so hard for people to see that. But I've asked that a million times. Should you have done this? Should you have done that? And the honest answer, I don't mean to sound arrogant, is I wouldn't have done it any differently. Somehow I'd have prayed it away, wished that I was on the shores of the Connecticut Sound, but failing that, I don't have any regrets.
I want to ask one last question unrelated to this topic on the issue of gun violence. Would you agree that universal background checks would help with law enforcement and prevention of gun violence?
The more able we are to keep guns out of the hands of criminals and spouse abusers and all the better. So the more information we have, the better for law enforcement perspective.
I'll take that as a yes. Thank you.
Before I call on Senator Tillis, I think we have one member that, if that member's going to come back for first round, then we have 3 or 4, maybe 5 of us that want a second round. So I hope that people will get back here so we know exactly how many people we have, out of courtesy to the Director Comey. Senator Tillis.
Director Comey, thank you for being here. I'm always impressed with your composure and your preparation. And I want to get to a couple of other things, maybe first, then if I have time, come back to what the hearing has been predominantly about. When you briefed us last year, I think that you said that there were ongoing investigations on Homeland Security, potential terrorists, either homegrown or foreign-inspired investigations in every state. Is that still the case?
Yes.
Do you have can you give me roughly an idea of the number of investigations that is?
Yeah, it's just north of 1,000.
Just north of 1,000.
Yeah, we have that caseload has stayed about the same since we last talked about it. Some have closed, some have opened, but about 1,000 homegrown violent extremist investigations in the United States.
And at the time, I also asked a question about to what extent that you can discuss it in this setting, were people who are the target of those investigations, persons who came in through various programs where questions about vetting have been raised as to whether or not they're accurate. At the time, there were a dozen and a half, I think, that you may have estimated. Do you have any rough numbers about that?
Yeah, I do. We have about 1,000 homegrown violent extremist investigations, and we probably have another 1,000 or so that are, I should define my terms. Homegrown violent extremists, we mean somebody, we have no indication that they're in touch with any
foreign
terrorists.
touch,
Yeah.
right.
Then we have another big group of people that we're looking at who we see some contact with foreign terrorists. So you take that 2,000 plus cases, about 300 of them are people who came to the United States as refugees.
Okay. And to what extent in all of those investigations, you mentioned earlier that there are probably about half of the various computing devices that you've accessed that you can't get into with any technology that the FBI has, which I assume is some of the most advanced available. To what extent is the access to that information relevant in these investigations of potential homeland threats?
Oh, it's a feature of all our work, but especially concerning here, because we're trying through lawful process figure out, are they consuming this poison on the internet, and are they in touch with anybody? And so it's true in terrorism cases, about half the devices we can't open. About 90-some% of our subjects are using at least one encrypted app as well that we can't read.
So, Mr. Director, just because of physical and technological constraints, half of the base of information you'd like to harvest you can't get to. Without 702, how much more of the remaining half would be harmed?
Well, the 702 actually addresses a different challenge. Yep. Losing 702 would be disastrous because it would lose our window.
It is relevant in these investigations, however.
It is,
yeah.
Because
that's what I mean. So half of the physical assets you can't already get access to. Then there's the metadata and all the other information that would be instructive to these investigations. So by going dark, do we mean 100%?
Well, we're headed towards 100%. 702 is our window into the really bad guys overseas. And if we close that window, I don't know why on earth we would close that window.
So we have thousands of investigations of potential homeland security threats, evenly split by either people who have self-radicalized or some who have been influenced, some who have come over in refugee programs, that we will basically pull the rug out from under you in terms of being able to actively investigate them, or I should say expeditiously investigate them.
Will certainly significantly impair our ability to investigate them. And that's what folks often say, why don't you get metadata? You can't convict somebody and incapacitate them based on metadata.
You've got to drill down. The Director Comey, in my remaining time, I want to go back to the investigation. And I just want to give you another opportunity to maybe finish by explaining the context that you were operating in. But I want to create the context going back to when the investigation first began. It was already a part of media attention. I think on June the 27th, the then Attorney General met with the spouse of someone who's subject to an active investigation, which was at the very least an unusual encounter, which also spun up the media. And then I think it was July 5th that you made the statement that I think a few of the things you've said that I guess based on the evidence you were gathering, there was one component, it was like removing a frame from a huge finished jigsaw puzzle and dumping pieces on the floor, something else that the media ties into. Then you said there is evidence of potential violations of statutes regarding the handling of classified information. And you went on to say that under similar circumstances, a person who's engaged in these activities would likely be subject to security or administrative sanctions. I mean, that was the tough part of the statement that you made. But you went on to say that you didn't believe a reasonable-minded prosecutor would bring a case even though there was evidence of potential violations, and that you were expressing your view that the Justice Department should not proceed. Is that typical for you to go to a point and say, I've gathered this information, there may be evidence of violations, but we don't think any reasonable prosecutor in the DOJ would pursue it, therefore we're going to recommend not pursuing it? Is that common?
For an FBI director to do that?
Yeah.
I've never heard of it. I never imagined it ever until this circumstance.
Was there some logic in that at the time that you were making that decision based on the information that you were provided? Was there the same sort of thought process that you're going through there to have it rise to that level that then led to your October 28th notification of Congress that you had to look at other evidence that had been identified on Anthony Weiner's PC. What I'm trying to do is say it looks like you were trying to provide as much transparency and as much real-time information as you had.
Yeah.
And then on November the 6th, the FBI apparently moved heaven and earth and got something done in a matter of days that they thought was going to take beyond the election. But you were in that pressure cooker. I just wanted to give you an opportunity to glue together, I think, the decision for your actions on July the 5th and how I think there's parallels between that and what you ultimately did on October the 28th and then November the 6th. And I'll yield back the remaining of my time for the answer.
And I've lived my whole life caring about the credibility and the integrity of the criminal justice process, that the American people believe it to be and that it be in fact fair, independent, and honest. And so what I struggled with in the spring of last year was, how do we credibly complete the investigation of Hillary Clinton's emails if we conclude there's no case there? The normal way to do it would be to have the Department of Justice announce it. And I struggled as we got closer to the end of it with a number of things had gone on, some of which I can't talk about yet, that made me worry that the department leadership could not credibly complete the investigation and decline prosecution without grievous damage to the American people's confidence in the justice system. And then the capper was, and I'm not picking on the Attorney General, Loretta Lynch, who I like very much, but her meeting with President Clinton on that airplane was the capper for me. And I then said, you know what, the department cannot by itself credibly end this. The best chance we have as a justice system is if I do something I never imagined before, step away from them and tell the American people, look, here's what the FBI did, here's what we found, here's what we think. And that offered us the best chance of the American people believing in the system, that it was done in a credible way. That was a hard call for me to make, to call the Attorney General that morning and say, I'm about to do a press conference and I'm not going to tell you what I'm going to say. And I said to her, I hope someday you'll understand why I think I have to do this. Well, look, I wasn't loving this. I knew this would be disastrous for me personally, but I thought this is the best way to protect these institutions that we care so much about. And having done that, and then having testified repeatedly under oath, we're done, this was done in a credible way, there's no there, that when the Anthony Weiner thing landed on me on October 27th, and there was a huge, this is what people forget, new step to be taken, we may be finding the golden missing emails that would change this case. If I were not to speak about that, it would be a disastrous, catastrophic concealment. It was an incredibly painful choice, but actually not all that hard, between very bad and catastrophic. I had to tell Congress that we were taking these additional steps. I prayed to find a third door. I couldn't find it. 2 actions, speak or conceal. I don't think many reasonable people would do it differently than I did, no matter what they say today. If you were standing there staring at that on October 28th, would you really conceal that? So I spoke. Again, the design was to act credibly, independently, and honestly so the American people know the system's not rigged in any way, and that's why I felt transparency was the best path. In July, and then I wasn't seeking transparency. In October, I sent that letter only to the chairs and rankings. Yeah, did I know they were going to leak it? Of course. I know how Congress works, but I did not make an announcement at that point. And then my amazing people moved heaven and earth to do what was impossible, to get through those emails by working 24 hours a day, and then said, honestly, sir, we found tons of new stuff, doesn't change our view. And I said, are you sure? Don't do it just because you're under pressure. They said, we're sure. We don't believe there's a case against Hillary Clinton. And I said, then by God, I got to tell Congress that, and no, I'm going to get a storm at me for that. But what I can promise you all along is, I said to people, you may think we're idiots, we're honest people. We made judgments trying to do the right thing, and I believe, even with hindsight, we made the right decisions. And I'm sorry for that long answer.
Director Comey, we have 7 times 6 is 42 minutes. I hope you won't want to take a break.
I'm made of stone.
Thank you. On March the 6th, I wrote to you asking about the FBI's relationship with the author of the Trump-Russia dossier, Christopher Steele. Most of these questions have not been answered, so I'm going to ask them now. Prior to the Bureau launching the investigation of the alleged ties between the Trump campaign and Russia, did anyone from the FBI have interactions with Mr. Steele regarding the issue?
It's not a question that I can answer in this forum. As you know, I've briefed you privately on this, and if there's more that's necessary, then I'd be happy to do it privately.
Have you ever represented to a judge that the FBI had interaction with Mr. Steele, whether by name or not, regarding alleged ties between the Trump campaign and Russia prior to the Bureau launching its investigation of the matter?
I have to give you the same answer, Mr. Chairman.
This one I'm going to expect an answer on. Do FBI policies, just the policies, allow it to pay an outside investigator for work another source is also paying him for as well? Want me to repeat it? Do FBI policies allow it to pay an outside investigator for work that another source is also paying that investigator for?
I don't know for sure as I sit here. Possibly is my answer, but I'll get you a precise answer.
In writing?
Sure.
Okay. Did the FBI provide any payments whatsoever to Mr. Steele related to the investigation of Trump associates?
I'm back to my first, I can't answer in this forum.
Was the FBI aware that Mr. Steele reportedly paid his sources, who in turn paid their sub-sources to make the claim in the dossier?
Same answer, sir.
Here's one you ought to be able to answer. Is it vital to know whether or not sources have been paid in order to evaluate their credibility? And if they have been paid, doesn't that information need to be disclosed if you're relying on that information in seeking approval for investigative authority?
I think in general, yes. I think it is vital to know.
The FBI and the Justice Department have provided me material inconsistent answers in closed settings about its reported relationship with Mr. Steele. Will you commit to fully answering the questions from my March 6th and April 28th letter and providing all requested documents so that we can resolve those inconsistencies, even if in a closed session being necessary?
Because as I sit here, I don't know all the questions that are in the letters. I don't want to answer that specifically, but I commit to you to giving you all the information you need to address just that challenge, because I don't believe there's any inconsistency. I think there's a misunderstanding, but in a classified setting, I'll give you what you need.
Okay. Well, I hope to show you those inconsistencies.
Now, and I think I know what where the confusion is, but I think in a classified setting, we can straighten it out.
Next question. According to a complaint filed with the Justice Department, the company that oversaw dossier's creation was also working with a former Russian intelligence operative on a pro-Russian lobbying project. At the same time, the company Fusion GPS allegedly failed to register as a foreign agent for its work to undermine the Magnitsky Act, which is a law that lets the president punish Russian officials who violate human rights. Before I sent you a letter about this, were you aware of the complaint against Fusion was acting as an unregistered agent for Russian interest?
It's not a question I can answer in this forum.
You can't answer that.
No, I can't.
Go on to something else. Last week, the FBI filed a declaration in court pursuant to Freedom of Information Act litigations. The FBI said that a grand jury issued subpoenas for Secretary Clinton's emails, yet you refused to tell this committee whether the FBI saw it or had been denied access to grand jury process from the Justice Department. So, I think a very simple question. Why does the FBI give more information to someone who files a lawsuit than to an oversight committee in the Congress? And that has happened to me several times.
I'm not sure, Senator, whether that's what happened here, but you're right. I refused to confirm in our hearings as to whether we'd used a grand jury and how. I think that's the right position because I don't know it well enough I don't think I can tell you, I don't think I can distinguish the statements made in the FOIA case as I sit here. But, yeah.
Well, just as a matter of proposition then, if I, Chuck Grassley, as a private citizen, file a Freedom of Information Act, and you give me more information than you'll give to Senator Chuck Grassley, how do you justify that?
Yeah, it's a good question. I don't,
What do you mean it's a good question? How do you justify it?
What I was going to say, it's a good question. I can't as I sit here.
Ye gods. Was the Clinton investigation named Operation Midyear because it needed to be finished before the Democratic National Convention? If so, why the artificial deadline? If not, why was that the name?
Certainly not, because it had to be finished by a particular date. There's an art and a science to how we come up with code names for cases. They assure me it's done randomly. Sometimes I see ones that make me smile, and so I'm not sure. But I can assure you that it was called Mid-Year Exam was the name of the case. I can assure you the name was not selected for any nefarious purpose or because of any timing on the investigation.
Last question. When was the grand jury convened? Was it before your first public statement about closing the case?
I'm still not in a position where I'm comfortable confirming whether and how we used a grand jury in an open setting. I don't know enough about what was said in the FOIA case to know whether that makes my answer silly, but I just want to be so careful about talking about grand jury matters. So I'm not going to answer that, sir.
Senator Feinstein.
Thanks very much, Mr. Chairman. Mr. Director, first of all, thank you for your fortitude in going through this. Appreciate it. In your testimony, you noted that the first half of the fiscal year, the FBI was unable to access the content of more than 3,000 mobile devices, even though the FBI had the legal authority to do so. I'm familiar with one of those, and that is the Southern California terrorist attack, where 14 people were killed in San Bernardino. Of those 3,000 devices that you weren't able to access, can you say how many of these were related to a counterterrorism event?
I don't know as I sit here, Senator, but we can get you that information.
Yeah, I'd really very much appreciate that. We had looked at legislation that would take into consideration events of national security and provide that devices, there must be some way of even going before a judge and getting a court order to be able to open a device. Do you think that would work?
Well, that would sure, to my mind, be a better place for us to be from a public safety perspective, but we aren't there now.
In terms, this week, the British Parliament's Home Affairs Select Committee released a report finding that social media platforms such as Facebook, Twitter, and YouTube failed to remove extremist material posted by banned jihadist and neo-Nazi groups, even when that material was reported. The committee urged tech companies to pay for and publicize online content monitoring activities and called on the British government to strengthen laws related to the publication of such material. Last year, I worked with Senators Burr, Rubio, and Nelson to introduce a bill to require tech companies to report terrorist activity on their platforms to law enforcement. What do you advise? The provision, we modeled it after an existing law, which requires tech companies to notify authorities about cases of child pornography, but does not require companies to monitor any user, subscriber, or customer. I plan to reintroduce the provision in separate legislation. So here are two questions. Would the FBI benefit from knowing when technology companies see terrorist plotting and other illegal activity online?
Yes.
would the FBI be willing to work with the Judiciary Committee going forward on this provision?
Yes, Senator. I don't know it well enough to offer you a view, but we'd be happy to work with you on it.
Well, I was so struck when San Bernardino happened, and you made overtures to allow that device to be opened, and then the FBI had to spend $900,000 to hack it open. And as I subsequently learned of some of the reason for it, there were good reasons to get into that device. And the concern I have is that once people have been killed in a terrorist attack, and there may be other DNA, there may be other messages that lead an investigative agency to believe that there are others out there, isn't it for the protection of the public that one would want to be able to see if a device could be opened? And I've had a very hard time. I've gone out, I've tried to talk to the tech companies, they're in my state. One, Facebook, was very good and understood the problem, but most do not. Has the FBI ever talked with the tech companies about this need in particular?
Yes, Senator. We've had a lot of conversations, and as I said earlier, in my sense, they've been getting more productive because I think the tech companies have come to see the darkness a little bit more. My concern was privacy is really important, but that they didn't see the public safety costs. I think they're starting to see that better. And what nobody wants to have happen is something terrible happen in the United States and it be connected to our inability to access information with lawful authority. That we ought to have the conversations before that happens, and the companies more and more get that, I think, over the last year and a half. But it's vital. We weren't picking on Apple in the San Bernardino case.
Right.
There were real reasons why we need to get into that device. And that is true in case after case after case, which is why we have to figure out a way to optimize those two things, privacy and public safety.
Well, to be candid, my understanding about some of this was that the European community had special concerns about privacy, and that some of the companies in our country were concerned, well, they would lose business. That European concern is changing. I think what I read about the UK, what I understand is happening in France and Germany, increased sharing of intelligence, the realization, I think, that they have very dangerous people in large numbers, possibly plotting at any given time to carry out an attack, has had some palliative effect. And there may be a change of viewpoint. So it would be very helpful if our law enforcement community could help us. And this is not to monitor. This is something that's very basic. If there is a piece of evidence that says, hey, there may be a cell, there may be another individual out there, you have a chance of getting into that piece of evidence to see if that's true.
All right, with a judge's permission.
With the judge's permission, that's correct. So I thank you for that.
Thank you, Senator.
Thank you, Mr. Chairman.
Senator Lee hasn't had first round, so I got to go to Senator Lee.
Thank you, Mr. Chairman. Thank you, Mr. Comey, for being here today, and thanks for your service to our country. I want to talk to you about something raised by one of my colleagues a little while ago about electronic communications transaction records. Would it be fair to say that electronic communications transaction records include such things as browsing history, one's history of websites that one might have visited on the internet?
Yes.
Would it be fair to say also that what one views, what pages one has visited, might in some ways be indicative of what one is reading?
Potentially, you're right. Even if you don't see where they went on the page, that they went to ESPN or Fishing Magazine, gives you some indication of their interest, yes.
Individually and collectively, you can find out a fair amount about a person, especially if you're able to review what it is that they've been reading for a certain period of time.
Right. The only reason I'm hesitating is, as I understand it, we can't look at all we can get is the websites visited, not where they went on the page or what they clicked on. But it does give some indication of your interest, just like who you call gives you some indication of your interests.
But where they went on the website will also be indicative of what they did on the website, would it not? I mean, if you can get that granular information about what subpart, not just that they went to ESPN, but they went to ESPN and read this or that article.
Right. My understanding is that we can't, with an NSL, as we understand the statute, get that sub-content. We can get the web page visited. We can't get where they navigated within the website. That's, I may be wrong about that, but I think that's how we are.
Within the existing confines of the law.
Correct.
And so for those who are proposing that we change existing law so as to allow you to use a national security letter to go further, as was suggested by one of my colleagues earlier today, that then would allow you to get this more granular information.
No, I'm sorry. I may have screwed this up. As we understand the way ECTR was intended to be used, that our NSL authority under ECTR, as we thought it was and as we hope it will be changed, is limited to that top-level website visit address.
Correct.
So even if it's changed the way we hope it will be, we don't get any deeper into what you looked at on a page. It's as if we're able to see what sporting goods store you called. We can't tell from the call record what you asked about. We can see what sporting page you visited, what website, but we can't see where you went within that.
Yeah. Based on the legislation that I've reviewed, it's not my recollection that that is the case.
Okay.
Now, what I've been told is that it would not necessarily be the policy of the government to use it to go to that level of granularity, but that the language itself would allow it. Is that inconsistent with your understanding?
It is, and my understanding is we're not looking for that authority.
You don't want that authority?
That's my understanding. What we'd like is the functional equivalent of the dialing information, where the address you emailed to or the web page you went to, not where you went within it.
Even if you look at it at the broad level of abstraction, so if you're suggesting it would be used only at the domain name level, somebody went to ESPN.com, if you follow someone's browsing history over a long period of time, you could still find out a fair amount about that person, could you not?
Yes, sure. And again, I keep saying this, but I mean it, as you can from their telephone dialing history.
Yes. Let's talk about Section 702 for a minute. Section 702 of the Foreign Intelligence Surveillance Amendments Act authorizes the surveillance, the use of U.S. signals surveillance equipment to obtain foreign intelligence information. The definition includes information that is directly related to national security, but it also includes, quote, information that is relevant to the foreign affairs of the United States, close quote, regardless of whether that foreign affairs related information is relevant to a national security threat. To your knowledge, has the Attorney General or has the DNI ever used Section 702 to target individuals abroad in a situation unrelated to a national security threat?
Not that I'm aware of. I think, I could be wrong, but I don't think so. I think it's confined to counterterrorism, to espionage, to counterproliferation, and well, those are the buckets.
Okay,
I was going to say cyber, but cyber fits within.
That's where it has typically used those things. Does it, so to your knowledge, it doesn't currently use Section 702 to target people abroad in instances unrelated to national security threats?
I don't think so. Like a diplomat to find out how someone feels about a particular foreign policy issue or something. I don't think so.
Right. So if Section 702 were narrowed to exclude such information, to exclude information that is relevant to foreign affairs but not relevant to a national security threat, would that mean that the government would be able to obtain the information it needs in order to protect national security?
Would seem so logically. I mean, to me, the value of 702 is exactly that, where the rubber hits the road in the national security context, especially counterterrorism, counterproliferation.
Okay. Now, when Section 702 is used, typically what we're talking about here is not metadata. It's not this call was made from this number to this number. This is content. And so if we were talking about two U.S. persons, two American citizens, if I were calling you, typically that's not something that Section 702 would be used to collect. But if it's me calling someone else, and if that person is not a U.S. person, if that person ends up being an agent of a foreign government, and if somebody has determined that communications involving that person might be connected to a national security investigation, there's a chance that that communication could be intercepted. Not just the fact the call was made, but also the content of that call.
Correct. That's what we call incidental collection.
And that incidental collection is then aggregated. You have databases that store all of these things. And so there are lots of U.S. persons who have had communications, conversations that have themselves been recorded that are out there in a database. Can you search that database for communications involving specific U.S. persons without getting a warrant?
Yes.
And the fact that these communications were intercepted without necessarily any showing of wrongdoing on the part of the U.S. person, without necessarily showing that that U.S. person had anything to do with the with the national security investigation at issue. Does that cause you concern that that could involve almost a backdoor way of going after communications by U.S. persons in which they have a reasonable expectation of privacy?
It doesn't cause me concern, but it may be because of the way, what I can see from where I am. I understand the question, though. But it's true, whether it's 702 or other court-authorized domestic surveillance in the United States, if we are covering a particular embassy of a foreign power and Americans call in and speak to them, we record that because we're authorized to collect the communications in and out of that embassy. And we store all of those in a database, or we have lawfully collected those, even though the American who called wasn't a target. The same happens with 702. If you contact or call a terrorist or someone we're targeting overseas, you're an American, you have a conversation, even though you're not the target, that's going to be collected and stored in a database. What matters is how we treat that data and that we're careful with it and we don't use it willy-nilly and we protect it in important ways. That's true whether we collect it in 702 or collect it domestically. I don't know how we would operate otherwise, and that's, yeah, I don't know how we would operate otherwise. I think what the American people want us to do is make sure we hold it so we can connect dots if it turns out there's something bad in there, but treat it like the U.S. person information that it is, protect it, and make sure that it's handled in a responsible way.
Senator Lee.
Thank you.
Thank you, Mr. Chairman. Director, let me tell you a story. About 100 years ago, literally, my Italian grandparents and my Irish grandparents faced discrimination because of their religion. Now, that discrimination wasn't violence, it was economic. This was not unusual in this country at that time. I like to think that's gone. I like to think of my grandparents, the Italian grandparents, the Irish grandparents, discrimination they faced because of both their race and their religion is not here. But now we see an alarming rise in hate crimes among minority communities. Yesterday, this committee heard some important testimony from the Department of Justice, from the International Association of Chiefs of Police, I believe our nation's largest civil rights organization, that law enforcement and political leaders must send a message that toxic, hateful rhetoric would not be tolerated. They must denounce bigotry wherever they encounter. Even as a child, I was taught that. We are never to discriminate against anybody because of their race or their religion. Now, what bothers me, let me show you this. On the campaign trail, President Trump promises supporters a Muslim ban. A campaign press release entitled Donald J. Trump's Statement on Preventing Muslim Immigration says that he called for a total and complete shutdown of Muslims entering the United States. Now, I can understand that dumb things are said during a campaign. That's on his website today. That goes beyond being stupid. Do you agree with me that messages like that can cast suspicion on our Muslim neighbors, can perpetuate division and hatred? And if it does that make America less safe?
Well, Senator, thank you. I'm not going to comment on the particular statement, but I do agree that a perception or a reality of hostility towards any community, but in this particular the Muslim American community, makes our jobs harder. Because as I said in response to an earlier question, those good people don't want people engaging in acts of violence in the name of their faith or in their neighborhood. And so our interests are aligned, but if anything gets in the way of that and chills their openness to talk to us and to tell us what they see, it makes it harder for us to find those threats. So we've been spending a ton of time. You're right about the increase in hate crimes. We've seen those numbers start to go up in 2014. They've been climbing since then. To redouble our efforts to get in those communities and show them our hearts and what we're like, to encourage people not to fear contact with us.
And Director Comey, I don't ask this to make a political point. I ask this as a United States Senator. I believe the United States Senate can be, and sometimes has been, the conscience of the nation. We're a nation with adherence to our First Amendment. We trust and we believe in all religions, allow you to practice any religion you want or none if you want. I worry, whether it's the Muslim religion or any other, you have religions where people believe in it, they should not be condemned, the actions of a few. I worry very much that the rhetoric and the hatred can bring about things that neither you nor I ever want to see in this country. I think we'd agree on that. Hate crimes, I don't care who it's against somebody because of their race or their religion. You as a head of the FBI, any one of us who've been prosecutors, we abhor all hate crimes, and I believe you do. Is that not correct?
That's for sure.
And I worry that we also give the impression that citizenship alone might be a reliable indicator of the terrorist threat posed by an individual to the United States. I think of the Oklahoma City bombing, one of the greatest acts of terrorism in our country, done by an American citizen who'd served, I believe, honorably in our military. So would you agree that citizenship alone is not a reliable indicator of a terrorist threat posed by an individual to the United States?
Correct. Most of the people that I talked about that we have open cases on are American citizens.
Thank you. In fact, the Department of Homeland Security, we've heard from them, they have an assessment from the Office of Intelligence and Analysis, concluded that citizenship is unlikely to be a reliable indicator of potential terrorist activity. Do you agree with that?
Yes.
Thank you. Another matter, Chairman Grassley and I have worked to address the concerns related to the FBI's hair and fiber analysis testimony has been flawed. I think we all accept in the past. Investigation began, I believe, 2012 after 3 men were exonerated here in Washington, D.C. because the FBI analysts gave inaccurate testimony. In order to review more than 3,000 cases, the FBI has reached out to officers that originally prosecuted these cases, and I appreciate that. I remain concerned that cases remain closed if you don't find the transcript right away. I've asked you this question in writing. In any cases where there's a missing transcript, will you commit to have an FBI conduct an in-person visit to obtain whether there was information that was used and possibly faulty analysis by the FBI that might have brought about a conviction?
I'm sorry, an in-person visit?
Well, to the prosecutor's office, whoever else may be involved, if you don't have a transcript, an in-person visit to say, okay, what do your records show? Did you use analyses that may have been faulty from the FBI and bring about the conviction?
I see. I don't know enough to react to that now and commit to it now. Can I follow up with you to see how we're thinking about that?
Will you follow up?
I will.
Written to you. Okay, thank you. Thank you.
Senator Leahy. Senator Whitehouse?
Thank you. Couple of quick matters. For starters, did you give Hillary Clinton, quote, a free pass for many bad deeds? There was a tweet to that effect from the president.
No, that was not my intention, certainly.
Well, did you give her a free pass for many bad deeds, whatever your intention may have been?
We conducted a competent, honest, and independent investigation, closed it while offering transparency to the American people. I believed what I said. There was not a prosecutable case there.
With respect to the question of prosecution for classified material, is the question of the consequences of the disclosure, i.e. the harm from the release or the actual secrecy of the material, considered in a prosecutive decision?
In my experience, it is, yes.
Because there's a great deal of material that, while technically classified, is widely known to the public, and because overclassification is a very significant problem within the executive branch, correct?
Correct. And DOJ reserves prosecution for the most serious matters, in my experience.
And that would have been evaluated also in looking at Secretary Clinton's emails.
Yes.
So although they were classified, they may not have caused any harm in terms of who saw them. Well, let me not make it specific to that. There are emails that could be classified and cause no harm if they were disclosed.
Yes, that is the case.
It has been disclosed and publicly reported that there was a 2-day interval between the FBI interview of Michael Flynn related to his conversations with Ambassador Kislyak and then Deputy Attorney General's report to White House counsel about those calls. Did you participate in conversations related to this matter during that 2-day interval? And what can you tell us about why that interval took 2 days? Was there some standard operating procedure that needed to be vindicated? Was there, you would think that that could have flipped over to a conversation to the White House a good deal quicker than that once the agent's report came back from the interview.
Yeah, I don't know whether the 2 days is right. I think it might have been a day. I could be wrong. Could have been 2 days. And I did participate in conversations about that matter. And I think I'll stop there because I don't know the department's position on speaking about those communications.
But as you sit here, you don't have any hesitation about that delay, about it representing any kind of, mischief or misconduct?
No. And given your experience, you know how this works. An agent conducts an interview. They're going to come back. They write up a 302. They show it to their partner. They make sure they get it right. Then they produce the 302. So sometimes it's the next day before it's finished.
So the deputy, Ms. Yates, would have seen the 302, and that process would have taken place by the time she went up to see White House counsel McGahn.
I think that's right, yes.
Okay, thank you. And on to the Weiner Laptop. As I understand it, you were informed by agents in the FBI office that there was potentially related or relevant information in Mr. Weiner's laptop. On the basis of that information, you then sent a letter to the members of Congress before whom you had committed to answer if there were any changes in the status of things. You also then authorized the agents to pursue a search warrant, which then gave them access to the content, which allowed them to do the search that you then said came up with nothing, so that you could then undo the letter and say, actually, we took a look and there's nothing there. Is that do I have the order correctly there?
Right. They came to me, they briefed me on what they could see from the metadata, why it was significant. They thought they ought to seek a search warrant, wanted my approval to do that. I agreed, authorized it, so did the Department of Justice, and then they reviewed, I was just making sure I get the numbers right. During the following week, they reviewed 40,000 emails. I understated how many they reviewed and found that 3,000 of them were work-related and came from BlackBerry backups and a bunch of other things. And
My
the
question is a little-
12 of them were classified, but we'd seen them all before. And
Yeah.
so they finished that work, they briefed me on it, and say, it doesn't change our view, and then I send the second letter.
Did any of those classified emails create national security damage?
That's a hard one to answer. By definition, the classification is based on the potential national security damage.
With respect to our earlier conversation, that
Yeah.
tons of stuff is classified that is on the front page of the New York Times.
Yeah. I'm not aware that any of these emails or any of the emails in the investigation got into the hands of people that were able to exploit them to damage our national security.
So let me offer you this hypothetical. They come to you and say, the metadata shows that we have potential information here that could be relevant and could cause us to reopen the information. It would seem to me that it would be as sensible at that moment to say, how quickly can you get a search warrant, and how quickly can we get an answer to that question, because I made a promise to people in Congress that I would get back to them with this information, and if there's anything real here, you need to get on that pronto so that I can answer that question, so that the search warrant precedes the letter rather than the letter preceding the search warrant, particularly in light of the widely adhered to policy of the department not to disclose ongoing investigative materials and the truly exceptional nature of disclosures.
Yeah.
Why not the search warrant first?
Well, I pressed them very hard on that and found credible their responses that there was no way they could review the volume of information they saw on the laptop in the time remaining.
Except that they did.
Well, they did, and because our wizards at our Operational Technology Division came up with a way to dedupe electronically that, as I understand it, involved writing a custom software program that's going to help us in lots of other areas. But the investigative team said, sir, we cannot finish this before the election. So that, to my mind, that then made the judgment appropriate, the one that I made, not waiting to make the disclosure.
Okay, and with just respect to your response to Senator Tillis, we can talk about it some other time. My time has expired, but lest silence be viewed as consent, I have a different view of what took place. I don't doubt your honesty for a minute, but I do think that there were very significant mistakes made through this process.
In the email case?
Yes.
Okay.
In the Hillary Clinton email case.
Got it.
Thank you to the ranking member, and I admire your hanging in there and being made of stone, was it?
Sandstone, I think.
I just want to clarify some of the answers that you gave me. For example, in response to Director, I asked you, would President Trump's tax returns be material to such an investigation, the Russian investigation? And does the investigation have access to President Trump's tax returns? And some other questions you answered, I can't say. And I'd like to get a clarification on that. Is it that you can't say, or that you can't say in this setting?
That I won't answer questions about the contours of the investigation. As I sit here, I don't know whether I would do it in a closed setting either, but for sure, I don't want to begin answering questions about what we're looking at and how.
Okay, so I'll take that as at least in this setting you can't do that, and maybe you can elsewhere. We're talking about some of the unusual number of individuals in important roles in the Trump campaign or in his life, and they're sort of unexpected and often undisclosed ties to Russia. And I'd like to focus on one of those individuals, Roger Stone, and his relationship with Guccifer 2.0. Guccifer 2.0 is an online persona that the IC concluded was used by Russian military intelligence to leak documents and emails stolen from the Democratic National Committee to WikiLeaks. The U.S. intelligence community, including the FBI, has since concluded that the Russian government directed the breach, and that Russian military intelligence used Guccifer 2.0 to ensure that the documents obtained were publicly released. So while Guccifer has insisted that he or she is not Russian, the intelligence community has concluded that the hacker has strong ties to Moscow and was used by Russian military intelligence to leak information about the Clinton campaign and Democrats that was stolen by Russia. Is that, Director Comey, a fair characterization?
Yes, the IC's judgment was Guccifer 2.0 was an instrument of the Russian intelligence.
Thank you. Well, a few months back, it was revealed that in August of last year, that's a couple months before the 2016 election, Roger Stone, one of President Trump's longstanding political mentors and at one time a formal campaign advisor, exchanged a number of private messages with Guccifer 2.0 via Twitter. Mr. Stone has since insisted that the relationship was totally innocuous. Now, in this series of messages, Guccifer 2.0 and Mr. Stone exchange a number of bizarre pleasantries. Guccifer thanks Mr. Stone for writing about him, and Mr. Stone expresses delight that Guccifer's Twitter handle was reinstated after having been suspended. But in one message, Guccifer writes to Mr. Stone, quote, "I'm pleased to say that you are a great man. Please tell me if I can help you anyhow. It would be a great pleasure to me." Director Comey, to me, this sounds like a clear offer from a Russian intelligence operative to collaborate with a senior official on the Trump campaign. Is that a throwaway line or an offer to help Stone in some respect? Do we know whether any further communication between Stone and Guccifer took place? And if you can't say here or can't say but you could say in another classified environment, could you make that distinction?
I definitely cannot say here. I don't think I would say in a classified environment because it calls for questions about what we're looking at and how.
Okay.
So, but I definitely can't say here.
Okay, well, at the very least, Stone's conversation with Guccifer demonstrated, once again, that the Trump campaign officials were communicating with Russian operatives. What is less clear, however, is whether the Trump campaign ever provided direction to Russian operatives or were aware that specific actions were being carried out to influence the election. For example, it has been suggested that last year the Russians used thousands of paid trolls, human trolls, we know this, and botnets to flood the internet, particularly social media, and with fake news aimed at influencing the election and favoring President Trump. I'm curious whether such actions were part of a coordinated effort. Is there any evidence that the Trump campaign assisted or directed those efforts?
That's something that I can't answer here, but I would refer you back to what I said was the purpose of the investigation, to understand whether there were any coordination or collusion between elements of the campaign and the Russians.
Of course, and I would point out too that that right before the Podesta emails came out, that Roger Stone said it's soon going to be time for Podesta's time in the barrel. And so I think there may be a little bit of a there. Before I end, I just want to, I only have 30 seconds, so I want to say this. I know Senator Cornyn isn't here. I think it's a shame that he said that Hillary yesterday in this forum blamed everyone but herself. She took a lot of blame on herself in that forum, and I think when she referenced what you did and in 11 days before the election, which has been a subject here, and also the Russian interference. I think she was only saying stuff that other people have said. I mean, I don't think she was saying anything that that a lot of people also think had an effect on the election. So I just think it was a shame that that the senator from Texas, I don't know if he meant to leave that out deliberately, but she did not blame everyone but herself. Thank you, Mr. Chairman.
Say, before I call on the next senator, there's two things I'd like to say. One would be for what you promised Senator Cruz about a briefing on the Garland situation, that you would include any of the staff of the committee in on that briefing as well, so we can have a committee briefing on it as well, at least at the staff level. Would you do that?
Assuming they have the clearances for it, I don't think that's a problem at all. I'll do that.
I guess that's obvious. The second thing is, after we have two more people have second round, before they get done, I have to go, and I want to thank you for being here. Senator Feinstein will close down the meeting. Thank you.
Thank you, Mr. Chairman.
I think under the previous order, Senator Hirono was ahead of you.
Mr. Chairman, I'm happy to follow Senator Hirono.
Okay.
Thank you. As mentioned earlier, Director, in March, President Trump issued a revised refugees and visa ban executive order that suspended entry into the U.S. from 6 majority Muslim countries. This suspension was largely premised on the claim that, quote, more than 300 persons who entered the United States are refugees are currently the subjects of counterterrorism investigations by the Federal Bureau of Investigation, end quote. Can you provide any additional information on whether the persons under investigation are from the 6 countries subject to the suspension? And are these persons exclusively from the 6 countries subject to the suspension? And if not, what other countries are represented among the population that is currently under investigation?
I'm sure we can provide you. What I can tell you here is I think about a third of them are from the 6 countries, so 300, about a third of them are from the 6 countries. I think 2/3 of those were from the 7th country, Iraq, that was not included. But I'll make sure my staff gets you the precise numbers, Senator.
So Iraq is the only other country that was not among the 6 targeted countries?
I think that's right. Obviously, as you ask it, I'm wondering whether I'm wrong. And so I'll get you the precise numbers. But
Thank you.
I think it was refugees, about 300, about a third from the 6 countries, about 2/3 from Iraq. That's my
Thank you. You can provide the information
Yeah.
later. Thank you very much. And can you provide additional information on the percentage of these individuals who came to the U.S. as children?
I can't as I sit here. I'm sure we can get you that
Can you
information.
check that? Thank you. And can you provide additional information on the percentage of these individuals who were radicalized after having been in our country for a long period of time? However way you would describe.
Yeah, that's a
long
harder
period
one
of
because
time.
it's very hard to figure out when someone is radicalized and then when it happened. I'll ask my folks to think about what information we can get you on that. We'll do our best.
Yes, thank you. Probably during the course of your investigation, you might be able to ascertain when they became radicalized. I'm turning to the death threats against certain judges. We have an administration that challenges federal judges who disagree with President Trump's views. We've seen this in the campaign and during his presidency. Following Judge Derek Watson's ruling blocking the president's revised travel ban, Judge Watson, who sits on the Hawaii District Court, Judge Watson began receiving death threats. I understand the U.S. Marshals have primary responsibility for the protection of federal judges, but that the FBI is poised to step in if necessary. Is the FBI investigating the threats made against Judge Watson?
I believe we are. I was last week visited the Honolulu field office and got briefed on our work, again, to assist the marshals in trying to understand the threats and protect the judge. So I believe we are.
And then in February, the 3 Ninth Circuit judges who ruled against the president's first travel ban also began receiving threats. Is the FBI investigating those threats?
I don't know that one for sure. I bet we are, but I can't answer with confidence as I sit here.
So can we say that any time federal judges are threatened, that the FBI would likely be involved in investigating those threats?
Probably in most circumstances, the marshals have the primary responsibility, and in my experience, they very, very often ask us for assistance on what information we may have, some of our technical resources. They're pretty darn good, but in most cases, I think we offer assistance.
And are the president's continued attacks on the judiciary emboldening individuals to make these sorts of threats? We're in an environment where some people might think that it's okay to issue these kinds of threats against judges who disagree with the president.
Yeah, that's not something I think I can comment on. It's concerning whenever people are directing threats at judges because their independence and insulation from influence, whether fear or favor, is at the core of the whole justice system, which is why we take them so seriously.
Yes, and so speaking of the independence of not just the judiciary, but I'd like you to clarify the FBI's independence from the DOJ apparatus. Can the FBI conduct an investigation independent from the Department of Justice? Or does the FBI have to disclose all its investigations to the DOJ? Does it have to get the Attorney General's consent?
Well, we work with the Department of Justice, whether that's Maine Justice or U.S. Attorney's offices, on all of our investigations. And so we work with them. And so in a legal sense, we're not independent of the Department of Justice. We are spiritually, culturally, pretty independent group, and that's the way you would want it. But yeah, we work with the Department of Justice on all of our investigations.
So if the Attorney General or senior officials at the Department of Justice opposes a specific investigation, can they halt that FBI investigation?
In theory, yes.
Has it happened?
Not in my experience, because it would be a big deal to tell the FBI to stop doing something that without an appropriate purpose. I mean, oftentimes, they give us opinions that we don't see a case there, and so you ought to stop investing resources in it. But I'm talking about a situation where we were told to stop something for a political reason. That would be a very big deal. It's not happened in my experience.
Well, a number of us have called for an independent investigator or a special prosecutor to investigate the Russian efforts to undermine or to interfere with our elections, as well as the Trump team's relationships with these Russian efforts. And should the Department of Justice decide that there should be such an independent investigator or special prosecutor, and you already have an ongoing FBI investigation into these matters, and the Attorney General has already recused himself, so how would this proceed when you have the Department of Justice conducting or assigning an independent or special prosecutor, and then you're already doing an investigation? How would this work?
Our investigative team would just coordinate with a different set of prosecutors. It's as if a case was moved from one U.S. Attorney's office to another. The investigative team just starts working with a different set of assistant U.S. attorneys. You don't miss a beat.
So the two investigations could proceed, but you would talk to each other.
Right,
Is that
it's
what you're describing?
it's one investigation, and the strength of the justice system at the federal level in the United States is the prosecutors and the agents work together on their investigations. And so the investigators would disengage from one prosecutor and hook up to another and just continue going.
So in the investigations that you're currently doing on the Russian interference and the Trump team's relationship, are you coordinating with any U.S. Attorney's office on
Yes,
those investigations?
Well, two sets of prosecutors, Maine Justice, the National Security Division, and the Eastern District of Virginia U.S. Attorney's Office.
So should the AG decide to go with a special prosecutor, then you would end your engagement with these other two entities and work with the DOJ?
Well, I could,
Special
yeah,
prosecutor.
potentially, or it could be that in some circumstances, an Attorney General appoints someone else to oversee it, and you keep the career-level prosecutive team. And so to the prosecutors and the agents, there's no change, except the boss is different.
If I could just ask one more follow-up question. So has this happened before, where you're doing an investigation and the Attorney General appoints a special prosecutor to conduct the same investigation?
It happened to me when I was in what I thought was my last job ever in the government as Deputy Attorney General, and I appointed Patrick Fitzgerald, then the U.S. Attorney in Chicago, to oversee a very sensitive investigation involving allegations that Bush administration officials outed a CIA operative. And so what happened is the team of agents that had been working for up a chain that came to me was just moved over and worked up under Patrick Fitzgerald.
Okay, thank you. So it happens. Thank you, Madam Chair.
Senator. Last but far from least, Senator Blumenthal.
Thank you,
patient.
Madam Chair. To take the analogy that you began with, I think we're at the end of the dentist visit, or toward the end of it anyway, and fortunately there's no unlimited time that the last questioner can take.
My dentist sometimes asks questions too.
To pursue the line of questioning that Senator Corona just finished, there is abundant precedent, is there not, for the appointment of a special prosecutor. In fact, there are regulations and guidelines for the appointment of a special prosecutor.
Yes.
And that has happened frequently in the history of the Department of Justice. You mentioned one in your experience. Also, then designee Attorney General Richardson appointed a special prosecutor, Archibald Cox, who then pursued the Watergate investigation, correct?
Yes, there's been many examples of it.
So this would not be a earth-shaking, seismic occurrence for a special prosecutor to be appointed. In fact, taking your record, which is one of dedication to the credibility and integrity of our criminal justice process and your families, I would think that at some point you might recommend that there be a special prosecutor. Would that be appropriate at some point?
It's possible. I know one of my predecessors did it. Louis Freeh did it with respect to a Clinton administration issue about Chinese interference in an election. So it's possible.
And I take your contention that you don't want to talk about your conversations with the current Deputy Attorney General, but my hope is that you will, in fact, argue forcefully and vigorously for the appointment of special prosecutor. I think that the circumstances here are exactly parallel to the situation where you appointed Patrick Fitzpatrick and others where routinely special prosecutors have been appointed. And I know that your recommendation may never be disclosed, but I would urge that you do so. Going back to the questions that you asked about your announcement initially that you were terminating the investigation of Hillary Clinton, you said that the matter was one of intense public interest, and therefore you were making additional comments about it. Normally, there would have been no comments, correct?
Correct.
And at most, you would have said, as you did just now, there was no prosecutable case, correct?
Correct.
And you went beyond that statement and said that she had been extremely careless, I believe was the word that you used, which was an extraordinary comment. Would you agree that the investigation of the Trump campaign's potential involvement in the Russian interference is also an investigation of intense public interest?
Yes, I agree.
In fact, there are probably very few investigations that will be done while you're FBI director that will be of more intense public interest. And my question is, will you commit to explaining the results of the investigation at the time when it is concluded?
I won't commit to it, Senator, but I do commit to apply the same principles and reasoning to it. I just don't know where we'll end up, so I can't commit sitting here.
But you would agree that as the FBI director, you would need to go beyond simply saying there's no prosecutable case or there is a prosecutable case?
Potentially.
When I was U.S. Attorney many years ago, there was actually a rule in the Department of Justice that there could be no report on any grand jury matter or any investigation without permission of the Attorney General or Main Justice. I don't know whether that rule still applies, but speaking more generally, do you think it's a good idea for prosecutors or yourself to be able to comment in some way to explain the results of an investigation?
Not in general, I don't. I think it's important that there be, as there has been for a long time, a recognized exception for the exceptional case. I referred to the IRS alleged targeting investigation, which was also of intense public interest, and then I actually had someone prepare for me a chart. The department has done it infrequently, but done it a dozen or more times in the last 5, 10 years. It ought to be reserved for those extraordinary cases, but there are times where the public interest warrants it.
With respect to the investigation ongoing into the Trump associates' ties to the Russian meddling, has the White House cooperated?
With the investigation?
Correct.
It's not something I'm going to comment on.
Have you had any requests for immunity from anyone potentially a target of that investigation?
I have to give you the same answer, Senator.
Would you tell this committee if there is a lack of cooperation on the part of the White House?
I won't commit to that.
Isn't there, again, another reason for there to be a special prosecutor? Because who would you complain to? The Deputy Attorney General? If there were a lack of cooperation on the part of the Trump White House?
If there was a challenge with any investigation that I couldn't resolve at the working level, I would elevate it to the Deputy Attorney General, whoever was in charge of it.
But the Deputy Attorney General is appointed by the President, correct?
Correct.
Isn't that an inherent conflict of interest?
It's a consideration, but also the nature of the person in the role is also a very important consideration. I think we're lucky to have somebody who thinks about the justice system very similar to the way I do and Pat Fitzgerald does and the way you did.
And let me ask, again, to just clarify a question that Senator Hirono asked. The career prosecutors so far involved are in the National Security Division in Main Justice and the Eastern District of Virginia, United States Attorney's Office, correct?
Correct.
But the decision about prosecuting would be made by their boss, I think is the word you use, correct?
Correct.
And that would probably be, right now, the Deputy Attorney General, correct?
Correct. In a matter of complexity and significance, the ultimate decision in practice is almost always made at the highest level in the department, which would be Rod Rosenstein.
And let me ask one last question, unrelated. You were asked by Senator Leahy about targets of investigation. I think your comment was that there were more citizens currently under investigation for potentially terrorist violence or extremist violence than non-citizens. Is that correct?
Correct.
In terms of sources of information, are there many non-citizens who have provided such information?
Yes.
And are a large number of them undocumented residents of the United States?
I don't know what percentage. I'm sure some significant percentage are.
So cooperation from them is important, and the fear of apprehension, of roundups, of mass detention would be a significant deterrent for them, would it not?
In theory, I don't know whether we've seen an impact in practice, though. I just don't know as I sit here.
Could you inquire or do some internal research to the extent it is possible and report back to us about it?
Sure.
Thank you, Madam Chairman.
Thank you very much, Senator. Director, I think this concludes the hearing. Let me thank you for your ability to last for many hours. It's very impressive. And let me also thank, ladies and gentlemen in the audience. Many of you have been here from the very beginning. Thank you for your attention, and Thank you for being respectful. It's very much appreciated, and the hearing is adjourned.
I'm from California, out here, one of your constituents. Just wanted to say, it's good to see you. We've been praying for you. And I wasn't able to make an appointment, but I did want to have an opportunity to just take a picture with you with my family. Okay? God bless you. Thank you, Senator.
Was exactly the shooting time I saw it. So before that, what happened, I didn't see it.
Had you ever seen the kid before?
No, because I didn't see their face. I saw them from sight. I was walking from this side.
And what did you do when you saw that take place? Did you run?
I ran back to the place I'm working, to the room I'm working, and locked the doors, turned off the lights.
Other than those 3 shots, did you hear anything?
No other shot, no screaming, no nothing. I just saw everybody was running.
I know it's tough to kind of get a sense of. This is an impossible situation to process, but how are you kind of processing what you've just gone through?
Well, it's not easy because this was the first time in my life I saw something like this happen. So a lot of things goes through your mind, but I wish that they were mature enough to handle whatever differences they had, to handle it in a civilized manner.
Do you have any friends on campus that you've checked in on, or?
Yes, I emailed our dean, our supervisor, and some people, and let them know that we are hiding in a room, and besides my family, and we all were trying to be quiet and not to talk, and let police take care of it.